to today's lecture in our distinguished lecture series titled Muslim Daughters' Inheritance Rights Under Shariat vis-a-vis Custom and Practices in India. So, before we begin, I would like to take a moment to acknowledge with gratitude the continued support and encouragement of our Honorable Vice Chancellor, Sheikhul Jamia, Professor Mazhar Asif, and respected Registrar, Sir, Professor Mehtab Alam Rizvi, for their continued support that makes that makes possible for centers like ours to continue to organize these meaningful academic engagements. I would also like to express my appreciation, my sincere appreciation to Professor Nishat Zaidi, who is the Honorary Director of Sarojini Naidu Center for Women's Studies and whose leadership continues to nurture the center as a very vibrant, intellectual space of discussions around gender, society, and justice. And also, as we mark Women's Day, it's an ongoing part of our Women's Day celebration. I think it is particularly meaningful that today's lecture focuses on a very important question of women's inheritance rights because it stands somewhere in the nexus or in the intersections of laws, customs, and lived realities. And I think it's a very important, pertinent question that should be part of the conversations around gender justice. So it's truly an honor for us to welcome our distinguished professor, Sylvia Vatuk, who's a professor emerita of anthropology at University of Illinois. On a personal note, I want to say that I've been chasing and corresponding with Professor Vatuk for almost an year now. When I invited her for our international conference on Islamic feminism, which was organized by our center under the directorship of Professor Nishat Zaidi. And at that time, you promised that you will connect with us. And I'm so grateful and thankful that that promise has been fulfilled today. And also, I want to say that despite the technical glitches, you managed to, log in through an alternative email ID to ensure that the session continues smoothly. So we at Sarojini Naidu Center are very, very grateful and thankful for all the efforts that you have made for today's lecture. Before I invite our distinguished chair to formally introduce our distinguished speaker for the day, I just want to say one thing, something that I read very recently, I think which marks the importance of today's lecture. So it was just, I think, 6 days ago, 10th of March. So there was this, Supreme Court of India was hearing a petition against it was actually the petition challenging the inheritance provision of the Muslim Personal Law Application Act of 1937 as discriminatory against Muslim women. And the Chief Justice of India, Justice Surya Kant, said just 4 words. He said that, the answer is UCC, which is the Uniform Civil Code. So these 4 words then they frame a very important, enormous question, and that question is precisely what brings us tonight, because what the court acknowledged, something that your work, your empirical scholarship that you have documented with almost meticulous precision, in Delhi, Hyderabad, Lucknow, that the Muslim daughters of India, in India, are routinely denied something which the Islamic law explicitly grants. So it's definitely something more than law to be, to be discussed and looked into. So with this, I invite our distinguished chair, Professor Nishat Zaidi, to please formally introduce our speaker. Thank you.
Thank you, Amina. On behalf of the Sarojini Naidu Center for Women's Studies, on behalf of all my colleagues present here, I extend a very warm welcome to Professor Sylvia Vatuk, who, as Amina rightly pointed out, we have been wanting to invite for a very, very long time. And I really don't have words, Professor Vatuk, to express our gratitude to you for accepting our invitation, and that too in a week when we are celebrating International Women's Day. Last year, we started this distinguished lecture series because last year we were celebrating our 25th anniversary. The center was founded in the year 2000 and completed 25 years last year. So to mark the occasion, we started this series in order to facilitate, intellectual conversations and create a platform where our students, scholars, and colleagues could directly interact with, distinguished scholars like you, whom they have read, whose works have shaped the way we think about gender in current scenario. To introduce Professor Vatuk, who in any case needs no introduction. We all have read her work and we all have been so influenced by her writings. But still, it is my duty to introduce you, Professor Vatuk. Professor Vatuk is Professor Emerita of Anthropology, University of Illinois at Chicago. With her two books, Kinship and Urbanization, White Collar Migrants in North India, that was published in 1972, and Marriage and Its Discontents, Women, Islam and the Law in India, that was published in 2017, and numerous scholarly articles on aspects of Hindu and Muslim marriage, family, kinship, organization, and the law in both northern and southern India, with a special emphasis on gender roles and intergenerational relationships. Sylvia Vatuk has been making vigorous and rigorous contributions to South Asian scholarship for decades now. Her works have been immensely helpful for anthropologists, sociologists, or just anyone, because I come from the field of literature and I know how much your works have shaped the way we look at women's writing and women's intellectual interventions. So her works have shaped scholarship in the field of gender, marriage, and kinship. While her initial research focused on North Indian Hindu communities, over the past 2 decades, she has also shifted her attention to Muslim communities of South India. Marriage and Its Discontent, Women, Islam and the Law in India is a compilation of papers she has published over the past 15 years based on this more recent work. The book uniquely focuses on encounters of Muslim women with non-state religious bodies, extrajudicial and state actors in Chennai and Hyderabad in addressing and settling their marital discords. And this is very important because usually whatever scholarship or majority of scholarship that we have vis-a-vis Muslim women, it is mostly confined to United Provinces and North India. So Professor Vatuk, we are so looking forward to your talk. So happy to have you. Thank you so much once again. Over to you. Floor is yours.
Well, thank you very much for those very, very nice introductions. And I must say that this is a great pleasure for me. I certainly wish that I were actually there, physically there at JNU. I have spoken and also visited different people, faculty, and so on at JNU over the years, but not very recently. And this is a very good opportunity for me to get back to that place. And I hope maybe someday I will actually be there, but I'll pretend that I am in the meantime. So I guess I should proceed here now. What's the best way? Can you see me properly?
Yes, yes, we can see you and we can hear you clearly.
Clearly. Okay, very good. Well, I'll just start. I will, it's a little disconcerting to be seeing all these little squares with different names and so on. So I got to get myself in a good position so that I can read without the glare. Okay, let's go. So as the title suggests, what I'm going to do is to talk about the question of an Indian Muslim daughter's share in the estate of a deceased parent. In most cases, this is the estate of a deceased father, but most of the things, in fact, all of the things I guess that I'll talk about also apply when the deceased is a mother. But as we know, not too many mothers have a great deal of property to disperse after their death. But in any case, So I'll be asking to what extent a daughter is aware of her inheritance rights under India's Code of Muslim Personal Law, and whether she is able in practice to avail herself of them. Indian women of all religions have the right to inherit from a deceased parent, although there are differences in the specific provisions in that respect among the different codes of personal law, those applicable to Hindus, Muslims, Christians, Parsis, and Jews, and under the Special Marriage Act. But as has been well documented by anthropologists and others, Indian women, like those in other countries of South Asia, rarely actually receive any share of their parents' estates. Instead, when the time comes, they typically either voluntarily waive their inheritance rights or they are prevented by their brothers or other male heirs, who are the usual executors, the wasi, of the estate, from exercising them. This is particularly true where immovable property, such as agricultural land or residential real estate, is concerned. The implications for women's well-being of this widespread practice are quite severe. The fact that the vast majority of land in India is owned by men and almost always transferred from generation to generation in the male line, from father to son, or in matrilineal communities, from mother's brother to sister's son, is one of the many factors contributing to women's overall low level of property ownership. It leads in turn to women's overdependence upon the male members of their family, their fathers, brothers, husbands, and sons, for their very survival. Women consequently have relatively little decision-making power within the conjugal family and are not only subject to the control of those upon whom they rely for sustenance, but also lack an independent economic basis for their own lives if they are alone in times of adversity. Those who lack a male breadwinner, divorcees, separated and abandoned women, widows, and the never married are especially vulnerable. Scholars who have researched this question unanimously report that the key reason that women so commonly refrain from claiming a stake in their deceased parents' estate, or even refuse to accept a share when it's offered to them by the male heirs, is based on their desire to remain on good terms with their brothers, to whom they may need to turn for assistance if they encounter marital or other personal problems in the future. Srimati Basu, for example, found in her extensive interviews about inheritance practices with women in 3 middle and low-income localities in New Delhi that few had dared to claim their own inheritance rights, saying that it was for fear of causing rifts with brothers and sisters-in-law. They felt that only by allowing the property to stay, and I quote, as part of their natal family's assets, could they be sure of maintaining harmonious relations with them. There's clearly a sharp disjuncture here between, on the one hand, the laws governing inheritance for the Indian state, and on the other, that country's cultural traditions and the practices they support. Thus, Indians of all religions tend to regard males as the rightful owners of land and other immovable property. Even when bought with the combined earnings or assets of a married couple, the land or houses they occupy, as well as most jointly used movable property, such as banks, investments, and the like, bank deposits, investments, and the like, are in most cases registered solely in the man's name. Females, on the other hand, are widely viewed as dependents. They are entitled to be maintained and cared for by the men of their natal family before marriage, and thereafter by their husband's family, and later by their sons. But they're not expected to control, and are often prevented from controlling, family property of the immovable variety. Most women do have some personal access to movable property, which comes to them in the form of the dowry, customarily given by a bride's parents to their daughter at the time of the wedding. Of course, all of you know about this. It typically contains an assortment of jewelry, clothing, furniture, and other household effects, much of which will be used to upgrade the furnishings of her marital home, though she may be able to keep most of the clothing and jewelry for her own use. When the question of inheritance arises, it is frequently the fact that her parents or brothers have spent lavishly on the wedding festivities, on her dowry, and on the associated expensive gifts for her groom and in-laws. And this is immediately provided as justification for her having failed to receive her rightful share of the inheritance. To date, the literature on the question of an Indian daughter's inheritance rights has been almost entirely based on research among Hindus. A number of years ago, aware that the topic had hardly been studied among Muslims, and since I had already done considerable research on the way that Muslim personal laws of marriage and divorce affect Indian women, I decided to begin looking into the question of how women fare with respect to inheritance. Therefore, in November of 2011, I began, with the help of a research assistant, to undertake a short-term exploratory study of the subject in the city of Delhi. As anthropologists, we did not attempt to systematically survey a statistically valid sample of informants using structured interview questionnaires. Instead, we conducted extended conversational style interviews of varying length with a total of 34 women and 6 men, seeking to discuss the topic with as diverse a set of individuals as possible. We went to different parts of the city and talked to women and men of different ages, classes, educational levels, occupations, ethnic groups, and family backgrounds. We limited ourselves, for obvious reasons, to families who owned or had previously owned enough real or movable property for its division among heirs to be a matter of practical concern. Because of time and funding constraints, our sample was small. We employed no systematic sampling method, but found our interviewees through a so-called snowball technique. We located some subjects through our own circles of colleagues and personal acquaintances, but most of them were referred to us by people whom we had already interviewed. A few were encountered accidentally in a variety of settings, expressed an interest in what we were doing, volunteered their views, and offered to relate some of their own personal experiences. While our findings are therefore in no way statistically significant, they do allow us to make some tentative generalizations about how differently positioned Indian Muslim women experience the negotiations over property that so often accompany a parent's death and its aftermath. In these conversations, we discussed a wide range of questions related to a daughter's inheritance rights in the law and asked them about the actual practice in their families and wider social networks when a parent dies. We aimed thereby to identify local, culturally shared notions about women's proper relationship to natal property, as well as to discover what they themselves knew or thought they knew about Islamic inheritance laws, how important they thought it was to follow these laws closely, whether their family and other people they knew were indeed following them closely, and if not, what they do instead when a parent or other family member passes away. Excuse me. In Islamic law, inheritance is the main avenue through which women can access property ownership. The laws of intestate succession give both sexes shares in the estate of a deceased spouse, parent, sibling, child, and, under certain circumstances, other more distant relatives. The percentage of the estate to which one is entitled depends upon one's gender and relationship to the deceased, but also upon the number of other survivors, their genders, and their relationships to the deceased. Generally speaking, when two or more heirs are related to the departed in the same way, the males are entitled to twice as large a share as the females. Lay Muslims often cite this rule in terms of an older Indian currency that had 16 annas to the rupee. And so they say that they interpret the rule now as, quote, 8 annas to the daughter, 1 rupee to the son. This makes a daughter's share half of a son's, a sister's half of a brother's, and so on. But the rules governing the distribution of an estate are far more complicated than this. And given the large number of variables that must be considered, calculating the number of shares to which each heir is entitled in a specific inheritance case requires specialized legal expertise that few Muslims possess. Therefore, when in doubt, the wasi of an estate often has to turn to a knowledgeable qazi, mufti, or other religious scholar and alim for guidance. In the Quran, individual heirs are grouped into a number of classes, of which only the first 2 need to be considered here. The so-called Quranic heirs constitute the first class. It includes 12 close blood relatives of the deceased, most of them female, each of whom is entitled to a fixed fractional share or hissa of the estate, 1/8 for the widow, 1/6 for the father, 1/12 for the mother, 1/2 for the daughter, but only if there is no son, and so on. When settling an estate, once each of these relatives has been assigned his or her share, the remainder of the property passes to the second class, the so-called agnatic class. This is constituted by the deceased's closest, mostly male, patrilateral kin. If the departed had sons but no daughters, the sons and other males divided equally among themselves. If, however, he had daughters as well as sons, they they take shares of the remaining property with their agnatic class brothers, according to the above cited 2-to-1 principle. Although a Muslim is allowed under Shariat to dispose of up to 1/3 of his property by writing a will, no heir to his estate may be one of the beneficiaries unless all of the other heirs agree. So in most cases, this is not at all a realistic option for a Muslim parent concerned to ensure that his daughter will still be provided for after his death. He may, however, make her a pre-mortem gift, hibbah. It is also possible, though more complicated, to do so by establishing a charitable foundation, a waqf, in her name. We learned from our respondents of several fathers and one mother who had done this. Okay. All of our respondents were aware that daughters have a right to a share of their parents' estate, but most were unclear about how large a share they would be entitled to. Their most frequent guess was 1/3, but this would only be correct if the only other heir was a brother. All agreed, however, that it is very rare for a woman to actually get a share of natal property that way when a father or mother die, and most felt it to be inappropriate and in any case very unwise for a woman to explicitly claim her share. None of our respondents admitted to having asked for a share of natal property themselves when a parent died, though a few said with pride that when their father had died, their brothers or other male heirs had been scrupulous about complying with the dictates of Islamic law, seeing to it, without their even asking, that they received what was due to them under the law. Men like this, who of their own accord had apportioned a share of the inheritance to their sisters, were spoken of admiringly for their generosity, open-heartedness, and fidelity to the dictates of Islam. Women who asked for their share, on the other hand, were viewed with disdain, characterized as greedy, selfish, and lacking in family feeling. We were told by several respondents that in such cases it was quite acceptable to take a share if the male heirs offered it voluntarily. However, even in such a case, they said it would be better, in order to ensure good relations in the future, to refuse such an offer. It was most reprehensible if a woman went so far as to openly demand, and they used the word mangna, or even worse, find a way to seize, kabza karna, her share against the male heir's wishes. A woman like that would not only alienate and irreparably damage her relationships with her brothers and other members of her natal family, but would suffer strong social disapproval from society at large. One of our respondents even suggested that if one's brother did generously offer a share of the estate to his sister, one should either immediately refuse or alternatively take the share graciously, but then insist on giving it back to him. That way, she suggested, both siblings would be commended by society, the former for having adhered to Sharia law and shown his love and consideration for his sister, and the latter for having placed family relationships above crass material interests. For many respondents, however, the whole issue was purely hypothetical, as they had never even heard of a woman laying claim to her share of parental property. Those respondents who did know or had heard of women who had done so said that it had created a serious rift between them and their natal kin, their brothers, brothers' wives, and children in particular. These women were no longer welcome in their natal home on either informal or festival and ceremonial occasions. Coming and going, आपस में आना जाना बंद हुआ. All, as had all the customary forms of ritual gift exchange, lena dena, between the siblings. And when these women later encountered personal difficulties, such as marital separation or health or financial crises, they were unable to rely on their brothers for assistance. It was, in these women's view, quite obvious that anyone who was thinking of asking for her share should first carefully weigh the monetary value of the property she hoped to obtain against the emotional value of the relationships that would be broken if she insisted on her legal rights. Only the most selfish and unfeeling woman would choose the former option. This said, we were able to collect a number of narratives about women who had received, whether through their own initiative or through the foresightedness, religiosity, or simple generosity of male relatives, a share of their parents' or grandparents' estates. But there was considerable variation in the circumstances under which this had occurred. Marital status was one of the significant variables. That is, single women, never married, or divorced, or widowed women were much more likely to claim or to be offered a share of the parents' estate or be provided for in some other way. Another sort of situation that we were told about is that a woman's husband and or in-laws sometimes pressure her to make a claim against her natal estate when her father dies. Usually she resists at first, but eventually complies, unable to withstand the continued harassment. In each of the actual cases we were told about, her natal family ultimately handed over the property, but thereafter effectively severed all ties with her. We also learned of some cases in which fathers had made financial provisions before they died for a daughter who had no other male protector by making a pre-mortem gift, by putting the hibbah I mentioned before, by putting money into a savings account in her name, or by buying a flat for her, or by legally transferring ownership of a portion of their family property into her name. Occasionally, a brother or a set of brothers had taken it upon themselves, sometimes in fulfillment of a promise to their late father, to set aside of the estate for their sister. There were also cases in which a woman who was already living in the parental home, this was true of many single women, but also of some married women who had been staying in the parental home when she married, and then the husband had come as Karjamai, some situations like that. Or sometimes they were already living in a house that was owned by the deceased parent and had simply stayed put, unwilling to be dislodged by the male heirs who were trying to do that. Sometimes the male heirs eventually accepted the situation, whether willingly or not, but we learned of 3 cases in which male relatives, brothers or father's brothers, were employing extreme and often devious measures, including in one case pursuing a legal suit to prevent a needy unmarried sister, niece, or brother's widow from exercising her right to occupy a portion of the natal family property. It is also the case that family properties are not always immediately distributed among the heirs, but are kept intact for 2, 3, or even more generations, and are only subdivided when one or a set of siblings, typically male siblings, in the 3rd or 4th generation demands their share, forcing the others to acquiesce to having it divided. This happens especially often if the ancestral property is agricultural land. In these cases, nowadays especially, the owners are living outside of their village. The owners, or most of them, are living outside of their village of origin, usually in a nearby urban area. In those cases, the land is usually cultivated by tenants or agricultural laborers, sometimes supervised by one of the brothers or a cousin who has remained behind in the ancestral home. Profits from the sale of the produce, the cases that we heard about, in the cases that we heard about, profits from the sale of the produce was typically divided among all of the family members, while shares of the produce itself were being sent to those living elsewhere, usually including women. So as long as family property, whether a business or land remains undivided, there is a greater chance that the women of the family are, as they said, taken care of in one way or another, so that there would be no question of their needing or even wanting to force a subdivision as a way of gaining ownership of their individual shares. Although in Islamic law there is no requirement or even an expectation that the bride's parents will give their daughter a dowry or jahez, but the originally Hindu custom is widely practiced by Indian Muslims today. All of our interviews confirmed that nowadays the bride's family is expected to present large amounts of gold jewelry, clothing, electronics, and household goods, including major appliances, to their daughter, as well as providing expensive gifts for the groom. Frequent examples that were given are a car, or for less well-off families, a motorbike. Also, with all of the electronic devices available today, these have also been added to the expectations for the groom's family's dowry gifts. But interviewees made a distinction between dowries that are freely given by the bride's families out of love for their daughter, and those extracted by the groom's family in the course of the bargaining over the terms of the alliance. The former practice was viewed positively and described as something that they and their families willingly engaged in, while the latter practice was strongly disapproved. I'm not able to keep track of the time. Could you tell me where I stand here? I was told I should speak for about 40 minutes, but I don't know. I can't keep track of the time. Are you keeping track? Well, never mind. Should I just go on?
Time, Professor. You have another 10 minutes, I guess.
Beg your pardon?
You have time, Professor. You have around 10 minutes or so.
10 minutes left.
Yes,
Okay,
yes,
that's
or
fine.
more than that, if you please.
Okay. Where was I? Okay, there is widespread perception that dowry amounts have been escalating among Muslims generally in recent years and have now reached unaffordable levels for most people. Since in the families of our interviews, however, most marriages were still, at the time of our field research, being arranged between close relatives, since the dowries given in such marriages tended to be relatively modest, most of those who spoke to us did not feel that it was a problem that directly affected them. However, some said that nowadays young people in their community, in their social network and kinship network, most of the young people are increasingly reluctant to marry a cousin, whether for fear of the genetic consequences of close kin marriage or simply because the thought of marrying a woman whom they had always thought of as a sibling made them very uneasy. So this trend may herald more serious changes in alliance patterns, leading to more marriages being arranged between strangers and a resulting increase both in the size of dowries and the prevalence of dowry demands. One of the questions that we sometimes raised in our interviews was how inheritance disputes, if and when they occur, are resolved. Our respondents usually indicated that if a dispute arose, attempts would first be made to settle it either within the extended family itself or with the help of elders in the caste community or local neighborhood. We found no evidence that such disputes were being mediated by religious functionaries. Although qazis as well as muftis are often approached for guidance when a family is faced with the question of how to distribute an estate among the heirs, we did not learn of any case in which such functionaries got involved when one heir felt that he or she had not received his or her due. The warden of a the warden of a Delhi madrasa, who was one of the men interviewed, discussed inheritance issues with us at some length. It was his opinion that if someone came to seek a fatwa on such a matter, he or she was likely to follow the mufti's instructions. Otherwise, why bother to seek a fatwa at all? However, he said that their office makes no attempt to follow up on whether or not the fatwa is indeed being followed. There is nothing to prevent some other member of the same family from coming in later to confirm the proper shares for each heir, but normally they only hear from one party so they have no way of knowing whether a dispute over the inheritance has later arisen. And even if they do learn about it, they do not regard it as within their scope of responsibility to intervene, nor do they have any power to enforce their decree. We came across 3 examples of 3 disputes being taken to court, but all of the cases dragged on for years and not only caused or exacerbated existing bad relations between the women and their natal kin, but never reached a final decision. Now, what recourse does a woman have under Muslim personal law if, notwithstanding the likely negative social consequences, she's determined to get whatever share of a parent's estate she's legally entitled to receive? On the one hand, as I just said, she could turn to a religio-legal venue like a qazi's court or what's so-called Sharia court. But apparently very, very few inheritance disputes ever reach these bodies, as they deal primarily with marital and other kinds of family conflicts, as well as with the registration of male-initiated divorces by talaq and the negotiation of women-initiated divorces by khulq. According to Catherine Lemons, who has done extensive ethnographic observation in and examined the records of such a Darul Quza in Delhi, there were no inheritance disputes being adjudicated there. This was also true of the Hyderabad Qazi and 2 others in Chennai and one in a district town in Tamil Nadu with whom I discussed the matter. These legal experts all said that they were sometimes consulted by men wanting to know how to distribute an estate, but none could recall having tried to settle a dispute arising out of the failure of male heirs to honor their sisters' legitimate claims. A few of the women interviewed for the study spoke of having taken complaints of this kind to the imam or jamaat of their local mosque, or to a neighborhood or community panchayat, or to the elders of their own caste or religious sect, only to come up empty-handed. The fact that religious authorities and members of community councils are exclusively male doubtless contributes significantly to this outcome. These men typically try to persuade the woman to abandon her quest in the interest of preserving family harmony. In any case, even if they wanted to help her to obtain her rights, they have no power to compel her male kin to adhere to the law. One noteworthy development in India and in Pakistan and Bangladesh as well is the recent growth of so-called women's courts or women's panchayats, whose purpose it is to provide a space wherein women's marital and domestic disputes can be heard and hopefully resolved by a knowledgeable and sympathetic jury of their own sex. Women activists in recent decades have set up such courts in cities and towns all over India, specifically to meet these needs for poor women. Most are run by women's NGOs, others by local or state government agencies that deal with women's affairs. And even those established by Muslim women activists actually welcome a multi-religious clientele, not just one of Muslim women. Those who approach these venues for help, like those who preside over them, are almost entirely female. they come seeking advice and assistance with marital problems and so on. But again, they have no enforcement powers and must rely entirely on moral persuasion. Their ability to influence local public opinion or on signed settlements between the feuding parties that may or may not be adhered to in the future. I have somewhat more to say about the role of the state in enforcing women's inheritance rights, but I think it may be time to end my formal talk and hear from some of you all, or questions or whatever. Thank you.
Thank you so much, Professor Vatuk. This was so insightful, more so because most of the things that you said are lived realities and everyday realities that
I'm still having a bit of problem hearing you, Nishat, somehow. Your voice is
You have to be a
softer
little
than...
louder, maybe.
I'll try to be louder. Is it better?
That's better. Yeah.
Okay, great. So, Professor Vatuk, I was saying thank you so much for your lecture, mainly because most of the things that you said are everyday realities. They constitute our everyday reality. Most of us are familiar with these situations, and still these practices, cannot be stopped. All of us, most Muslim women know of, aunts or their own mothers who have either, willingly, given up their share in favor of their brothers, never asked for it. What is called dukhtari is such a fraught question, in Muslim society. So thank you so much for your talk. I will pass on to Amina to take up questions from the chat box. Because if I go on, you will not get to answer the questions from the audience. Amina, over to you.
Yes, thank you. Thank you so much, ma'am. So I request everyone to please post your question on the chat box. I see a few questions here and I'll pick them one by one. So one of our student wants to know, and she's referring it to The Second Sex by Simone de Beauvoir, where she argues that women are often treated as other rather than an independent individual. And in many traditional societies, including Muslim communities, women are frequently seen as a responsibility for the family, where marriage becomes a primary duty that the parents feel that they must fulfill for their daughters. So, how can we understand this practice, through Beauvoir's, idea of women being treated more like objects of social duty rather than, autonomous individuals?
Well, I mean, this questioner is absolutely right about the way that they are thought of. I mean, it doesn't mean that the women are being necessarily treated badly in other ways, either by their natal kin or by their, husbands or families, but simply that this has so long become an accepted way of dealing with it. I think the whole idea of that women are the responsibility of a family, either their natal family before they're married and their husband's family afterwards. They're just not thought of as I mean, maybe this problem is declining, perhaps, but they're not really thought of as like independent, and certainly not economically independent persons. So I don't know if that's actually satisfactory response to the question, which really, is sort of what lies behind the whole thing. As I said, I mean, it's the view of males versus the view of females and where they belong in society. That's the source of this problem, or one of the main sources of this problem.
So with this, I want to move on to the next question. Professor Vijayalakshmi Brara, who's a professor at our center, wants you to reflect about the marriages, the Christian marriages. So although your study is primarily on the Muslim and the Hindu woman, but if you can reflect on the Christian marriages in the same context, maybe.
Yeah. Well, actually, of course, each personal law, codes of personal law are different in terms of this, but Christians, Hindus, in all of the religious codes allow women to inherit, and Muslims are the only ones that make it, a different percentage of the estate. The Christian and the others also say, they should share equally with their brothers. There was a very famous or infamous dispute within Christian issues, but that did not involve daughters as such. That was really in terms of other wives, and anyway, there was a different kind of case altogether. So the difference between Muslims and others is that in the Muslim case, it adheres to a set of rules which distinguish between the rights of women and those of men, and consistently gives women less rights. Even if they are given it, it's still always less than what a brother in the same position would get.
I'll quickly move on to questions. We have questions pouring in. This one is by Director, Professor Nishat Zaidi, and she wants to know, do Muslim inheritance laws vary from state to state? Are cases of families with only daughters treated in the same way as those of families with both sons and daughters, or only sons? And what is the level of intervention of the state which is keen to protect the rights of Muslim women?
Well, in terms of the first question, I'm not too sure about the first part of that question. Could you just...
Yes. Let me, I'll repeat. Do
just
Muslim,
the first...
do Muslim inheritance law vary from state to state?
Oh, okay. No, they do not, because the Muslim personal law doesn't vary in any way from state to state. It's the interpretation of Sharia, the Quran, and so on. It's nothing to do with what state you're in, and that's what is that is what is administered as Muslim personal law, which is a federal law. Now, the other part of the question, how does the state get involved? Well, the state gets involved, and that's what I didn't have time to go into. Mm-hmm. The state gets involved if someone decides to go to court and fight it. Now, it's hard to really see. Most of these cases would go to the district court, either a man, and in fact, most of such cases, as you see when you look at the ones in the higher courts, most disputes are between men. It's where brothers against brother, or a man against his cousin, or uncle, nephew. So, but anyway, even the ones that involve women, you can't really, except by going to the district court and look at the records, which would be a very good thing for people to do. You can't say how common they are or what sort of what results from them, but you can look up appellate cases, and so if you do that, and I have done that, and that's what I didn't really have a chance to talk about. There again, most of the appellate cases involving inheritance are brought by men, and mostly not against women, although sometimes men against women, but mostly men against other men. The very few cases where women have brought cases saying that they did not receive what was due to them, and even a few cases have gone up to the Supreme Court. But these usually involve very large families, families with a lot of property of various kinds, and families with very complicated relationships among them. Men who've been married more than once, or who've had children by a legal wife and then children by a mistress, or some woman who was not, to whom they were not married. So these cases are very atypical of the the run-of-the-mill ordinary people disputes. And it's also so expensive. That's part of it, but also because those people have much more at stake when they try to. So basically, for the ordinary person, the idea of taking it to court doesn't make much sense. And in those cases, I said I had come across in these interviews narratives, and in fact, one of the cases I knew the people personally. The cases just went on, and it went against the man, and then he appealed it, and then to a higher level and so on. But I didn't find any case where someone was actually got what they wanted. And of course, even if they did get what they wanted, they were already in really bad terms with the rest of the family. So taking it to court was only, if you really, really wanted and you had access to controlling property, you wouldn't even bother to try.
As you said, the Muslim women have to choose between the emotional value or the monetary value. So
That's right.
Yes, I'll move on to the next question, and this one is slightly longer, so I'll break it down. So this one is by Dr. Firdaus Azmat Siddiqui, who's also, who's also a professor at at our center, and she's asking this: do you find any relationship between increasing dowry demand and changing pattern of marriage among Muslims? For example, Muslims are increasingly now inclined towards marrying in among strangers, unlike the earlier times when they were marrying, within the cousins, cross cousins. So that would often discourage the unwanted dowry, and since they were related by the blood, so the property will remain in the family. So, and there is a second part to it as well. She wants to know, do you think the reason behind the denial of the share or the inheritance is because of the colonial legacy that was provided as an option in the Shariat Act of 1937? So I think I'll stop here for you to reflect. This is a long question.
Yeah. Do I think that it is a result of
the colonial legacy? Do you think that has an impact on the way the Shariat is promulgated in India?
Well, of course, to answer the second part of the question about the British, the colonial period and so on, of course, the Muslim personal law, as it stands today, has its origins in the period in which the British were taking over the administration, including the judicial system, and and it was they who originally decided that they didn't want to interfere with the local religious rituals and so on, practices of the population, clearly because they were afraid that this would make it difficult to control, that there might be protests or other things. So you have to say, of course, when you go back to see the origins of it, but we're talking a couple of centuries. So, and furthermore, there's no reason to think that before the British came, that Muslims were adhering to their, adhering to the Quranic prescriptions. Before, of course, they doubtless were not adhering in those days either. So it wasn't codified in those days before the British came, but it was certainly, one can only say it was probably being practiced in the same way. It wasn't that suddenly women stopped getting what they'd been getting all along. I doubt that very much. So anyway,
So, Professor.
and the other part of the question by Professor Siddiqui, what?
So she wanted to know whether, the changes in the marriages among Muslims, so they are more marrying among the strangers,
they're marrying more.
like earlier. So do you think it has something to do with the inheritance, rights of women?
Right. Yes. Well, I did briefly touch on that. And of course, it is true that there is an increasing tendency among those who previously, and many who still do, prefer to marry cousins, that this is changing, and more of the marriages are being arranged with strangers. I remember some discussions about this trend, and some people said, well, this is because of the increasing sort of capitalistic mindset among Indians generally, that a lot of young men are feeling that marriage is one of the only ways that you're going to get a good stake in life. And so there are more and more demands. Well, you can't demand it from your relatives. So you go out and you try to get the best deal that you can when you arrange the marriage. I don't know if this sounds familiar to any of you, but I expect that it does. But certainly for other reasons also, there is a trend toward marrying outsiders, and that goes along with an increase in the amount of dowry, and also an increase in the extent to which the dowry is being demanded rather than being offered just as a, kindness or whatever, a desire to make the daughter's experience when she gets married in her marital household to have a better time. Yeah.
So, Professor, I want to check on you. Are you okay? Because we initially, when I was telling you about the format, we had only 10 to 15 minutes for the Q&A. But obviously, there are more questions. We can email these questions to you and you can respond to them. If you're comfortable, we can probably take a couple.
Yes, I would be happy to do that.
All right.
Yeah.
So shall I continue with few more questions, Professor?
Yeah, a few more. Yeah.
Okay, all right. So this one is by Parvez, who is a student at our center, student of gender studies, and he wants to know from your experience and observation, have you encountered any case where a person's, share in property was actually restored or it was secured through waqf, through the creation of waqf? Was waqf in any way, instrumental in the inheritance rights? in your experience?
Well, I had actually encountered a couple of those cases, but it's not very easy to do. I mean, it's not that simple to set up a waqf, and also except families with quite a lot of resources are probably, they need to have some sort of guidance, legal guidance. Like the ordinary person wants to do it, they don't just sit down and say, okay, I'll write it up like this. They have to get. So I really just know of a couple of cases, but and that presumably worked, but I don't know what happened afterwards because I only learned about it, that they were in the process or had done it. But the person has to die before it really is of any benefit to the person of the waqf, whose name is on the waqf. Yeah.
Thank you, Professor. So I think this would be the last question that I take. And this one is by Dr. Suraya Tabassu, who's an assistant professor, at our center at Sarojini Naidu Center. And she's reflecting on her own study, and she says that your lecture actually, took her to her own work, her own research on the same topic. And she said that out of 1,000 respondents, only 3 women received the property right. And those who did not get it was because of the reasons you have mentioned. So she just wants to know from your own experience and research, how does the religion and the culture, how does it play out in this rights for inheritance? And also, Professor, I want to say that there are lots of questions that I have in the chat box, but I will not take them up. But I can email this to you, including my own question, which I will not ask. But I will, of course, continue correspondence. Is also, Professor, we have lots of messages thanking you for this lecture, for taking time, and making this possible. So we have lots of messages from the students and faculties thanking you. So yeah, so this one would be the last.
Well, I really appreciate all those sentiments. I enjoyed doing it, and I wish that I had more to say, but that was significant. I mean, most of this, of course, as it's not news. What I've said is not news at all, but just to sort of document it from the best way that I can. So thank you very much. And I'd be happy to look at these emailed questions and respond that way. Thank you. It was a pleasure to meet you all.
Thank you. And I think with this, we have come to the end of this yet again very insightful, distinguished lecture series. And I would like to now, as we come to the close of this, very insightful, lecture, it is my privilege to now propose a word of thanks. It's an official, it's part of the, format of our distinguished lecture series. So I would like to first, express a heartfelt gratitude to Professor Sylvia Vatuk for her lecture. And I would like to thank all those who have joined, from students and faculties and students from other departments who made possible, who tuned in for this lecture. And also, of course, I want to put on record my deepest gratitude for our institutional head, Professor Mazhar Asif, our Vice Chancellor and our Registrar, Sir, Professor Mehtab Alam Rizvi, for giving us this opportunity, for allowing us, giving us the space where we can engage in these discourses. And of course, my gratitude also goes to Professor Nishat Zaidi, Honorary Director of Sarojini Naidu Center for Women's Studies, for chairing today's session and for her continued leadership in nurturing the center as a vibrant hub and space for these, feminist scholarship, dialogue, and collaboration. So I think with this, we have come to the end. I would also like like to thank our technical support team and students volunteer who make this happen seamlessly and work behind the scene. So thank you, everyone. And we'll meet again in another distinguished lecture series very soon. Thank you so much.